Good morning, everybody. Happy super duper ooper schmooper Friday. That sounds right. Glad to have you all here. Let's have a great day today. We'll start out with Judge Glazer in Miami-Dade, who, may or may not be having a good day. You never know with her.
And the scratch marks led him to the opposite direction towards the residence of Mr. Alvarez, I guess his neighbor. Defendant approached him, apologized for what happened, saying it was his son's birthday. I guess he wanted to get him a new air conditioner for his birthday from his neighbor. All right, so he had CCTV as well. Sir, do you own your home? You own your own home?
Yes, ma'am.
You don't qualify for the public defender's office. You're going to have to hire a lawyer. Do you want me to reset the case in the afternoon to give you an opportunity to get a lawyer? Or do you want me to just proceed now and set a bond so you can get out of jail quicker and waive a lawyer's presence?
I just don't have a way to get a hold of my family. Because I don't know no numbers. I don't know my sister's number or my wife's number by memory.
Okay. In the meantime, do you want to waive a lawyer's presence for the purposes of this hearing, or do you want me to reset it for the afternoon so you can try and secure a private lawyer?
Whatever's the best, man.
It's your choice. It's not mine.
Well, what is she trying to tell me? What is she trying to?
You have a right to have a bond. You have a right to have a bond set now or later. If you want to do it now, you need to waive the presence of a private lawyer. I'm not appointing the public defender's office for you.
Okay, I guess I'll a bond.
Okay, so you're willing to waive the presence of a lawyer to represent you on this first appearance hearing? If not, I'll reset it for the afternoon.
What do you think would be the best for me?
Okay, he doesn't know. Sir, I'm going to reset it for the afternoon. That way you're not being pressured into do anything. I'll reset for private attorney in the afternoon. I'll make a preliminary finding of probable cause. See you later.
Judge, did you want to hear from the victim? Is that why we called this out of turn?
I don't know. There was somebody here who wrote. Yeah, I did. 1 second. I didn't know if the victim wants to be heard. Can she raise her hand and I'll promote her? Let me promote her. Is the victim there? Miss Evelyn? 1 second, please. Yeah, that's why I called it out of turn. Hi, Miss Evelyn. Are you able to?
In Your Honor.
Can you raise your right hand to be sworn, please?
Yes.
You swear or affirm the testimony you're going to give in this proceeding will be the truth. If so, state I do.
Yes.
Okay, what is your name, please?
My name is Evelyn Rodriguez Stanton.
Okay, what do you want to tell the court?
I just want to tell the court that I am my mother's proxy, that I'm very sad that Mr. Alvarez did this, and that I've known him as a child. And I was very disheartened when I heard the news.
Okay, well, I'm going to order him to stay away from you. Is Evelyn, you're Evelyn Stanton, but do you live there or does your mom live there?
I'm back and forth, Your Honor, because I care for my mother who's elderly.
All right. So, sir, I'm going to order that you want a stay away order?
Yes, please, for both my mother and I.
Now, how far away is his home from yours? Is it right across the street?
Yes, it's like four houses down.
Okay. Is it within 50 feet from your house?
I'm not quite sure.
Okay, fine. Sir, you are ordered to stay away from Evelyn Stanton, the alleged victim. No contact with her, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet. I'm sorry, I'll make it 25 feet away from you. Is that okay, ma'am?
Yes, and also my mother.
What is her name, please?
Aurelia.
How do you spell it?
Aurelia, middle initial A, last name Rodriguez.
Thank you. You're also, stay at least 25 feet away from the victim, her home and school and place of employment at all times, and no contact with the victim through social media, email, texting, or any other type of electronic communication. And stay away from their residence at 3532 Northwest Second Terrace in Miami, Florida. Do you understand the stay away order?
Yes, ma'am.
All right, thank you. So it's 25 feet away. I'll reset the case for the afternoon so he can call in an attorney if he so chooses. All right,
Was there any way that I could get a bond hearing now?
you can get a bond now if you want to waive
Yes.
the lawyer's presence.
Yes, yes.
Okay, so count one, burglary to the unoccupied dwelling is $7,500. Ma'am, was anybody home at the time?
I do not know, Your
Okay,
Honor.
fine. There's probable cause for count one. Count two, there's probable cause for, I don't know what the dealing in stolen property is. I don't,
Guys, he sold it for $300. Hold on, let me see.
$300 to repair the driveway.
See where the,
I thought he was buying it for his kid's birthday. I mean, he sold it for his son's birthday.
hold on. Wait, he sold it for scrap.
Okay. Ma'am, how old's your mother?
My mother just turned 86 years old,
So
ma'am.
now, and her 86-year-old mother has to be in a house with no air conditioning because of your alleged actions. There's probable cause for count two, dealing in stolen property. I don't know what bond you want state.
But I mean, of note is they needed to get the
Excuse me,
SWAT
ma'am.
team out there.
What? Okay, count two, dealing in stolen property. I'll set it at $5,000. Count three, grand theft. There's probable cause for that charge, $2,500 bond. Count four, criminal mischief. There's probable cause it's over $200. That will be $500. So his total bond is $15,500. Stay away from the victims. Oh, more. I'm sorry. Resisting without is $500. And count six, disorderly conduct. Sorry. What's a disorderly conduct?
I think it has to do with when they took him into custody.
Okay.
It says,
LROR count six. And so the total bond is $16,000. Good day, sir.
What was count four, Your Honor?
Count one is $7,500. Count two is $5,000. Count three is a $2,500 bond. Count four is $500. Count five is $500. Count six is ROR.
Thank you.
Thank you for coming in, Ms. Stamp.
Judge, whenever the court's ready. we can-
I'm ready.
So we need to preempt court for a minute. Ashley throws down 50 gift memberships. Bailey throws down a super sticker and then follows it by 20 gifted memberships. I hope I express well enough how grateful I am for all of you. I really do. Without all of you, without this community, I'm just some guy showing court, yelling into a microphone, and hopefully somebody listens. You all make this special. Michael throws down 5. This is the reason why I get up every morning. This is the most fun I've ever had in any kind of job that I've ever done. It is a privilege to be able to spend time with you guys. It is an honor. Barbara throws down 5. This is now a new record, by the way, for a single day. And we're not even 15 minutes in. Lindsay throws down 10. I hope I'm worthy of this. Let me just put it that way. I try every day to just be worthy of your time, your attention, and support. And I promise you that I'll keep doing everything I can to be worthy. We'll leave it at that. Thank you so much, everybody.
and he bought the pills for $25 each, and they would last for a month. So there's probable cause for the charges. Well, trafficking in fentanyl is a crime which is considered a dangerous crime. The state filed a motion for pretrial detention pending final hearing. So I'm going to hold you with no bond. You're going to see a judge tomorrow. That judge will set a final
Monday.
hearing on the state's motion for pretrial detention. Monday, not tomorrow. Let's say Friday. Oh, Monday. Okay. Do you ready now, Ms. F?
As soon as corrections.
Corrections, are you ready?
No, they're on their way there now.
Who's this? This is Mr. Robinson?
Robinson.
Andre Robinson, his parents are here?
Yes.
Good morning. Sir, this is page 13. You were arrested for grand theft, 3 counts of fraudulent use of personal identification, organized fraud, over $20,000, but less than $50,000 in possession of credit card making equipment, and unlawful possession of a scanning device or re-encoder. I will appoint the public defender's office for you. So this, let's see, there's a bank investigation. They got a search warrant regarding fraudulent use of identity and grand theft of over $25,000 involving 2 individuals. The bank issues private label credit cards for retail partners. So it says in August 2025, they're investigating after there's multiple same individuals appeared in multiple videos tied to accounts open under stolen identities.
Would he be able to get a bond?
We'll see. It revealed that Mr. Robinson submitted numerous fraudulent applications using stolen personal information. Once accounts were approved, they changed the mailing address to fraudulent locations so new cards would be mailed in the victims' names. And the fraudulent address was identified as his residence, where you live. I guess you live with him?
Yes.
Yeah, okay. So he listed this address on this Florida Department of Motor Vehicle address, and it's the same residence used during their verifications. 23 counts were redirected to this address. So he's involved in a rather large-scale fraud activity, apparently. And then they list all the fraudulent cards that were in purchases. $1,300, 1,339 cents of fraudulent purchases on a Lowe's credit card back in April of 2024. On July 2024, another card was mailed there, over $700,000 of fraudulent purchases followed. Then in September 28th, 2024, another bank account. Wait. He attempted to remove the account block. Let's see. Then there's another victim from April 2024. So it looks like it may go back to 2024. They did, I guess they've got a search warrant. They found in his residence, bank card letters made out to various victims. In his closet, he had an embossing machine consistent with manufacturing stolen credit cards. He had a small safe containing multiple gift cards that appeared to be purchased through fraudulent means next to a stack of U.S. currency totaling $3,622. So I believe there would be probable cause for everything. I don't know, Ms. Corey, you have anything you want to say?
No.
No. Count 1, grand theft is going to be a
Judge, in
25.
terms of the bond, I think an increased bond is warranted based upon this sophisticated nature of this.
That'd be a requirement is warranted to make sure the money used to post the bond is from a legitimate source of
Also
funds.
asking for an EBI as well.
I don't know about rate. Count 1, grand theft is $2,500. Let me see, is it a first or second degree grand theft? It's a lot of money. This is for, all right, grand theft, I'm setting it at $5,000 bond. Count 2, 3, and 4, fraudulent use of personal identification. I don't know why it's charged as a first-degree felony. It's a third-degree felony. $2,500 count 2, $2,500 count 3, and $2,500 count 4. Count 5, organized fraud. There's probable cause for that. $7,500 bond. Count 6, fraud, unlawful possession of credit card making equipment will be $2,500. Count 7, unlawful possession or use of a ring encoder is $2,500. That's plus a Nebia requirement. You have to show the money used to post your bond is from a legitimate source of funds.
His mother, would they be able to reduce the bond? Because I'll be able to pay it to get him out.
How do I know the money you're using is not, he's living in your house
Oh,
and all
no.
this is going on?
Yeah.
I think you're gonna have to
I have to show proof. I have proof. 'Cause I
You-
work.
you're gonna. I don't know, states, she's asking me to lower, should I leave count 1 at
Judge, I think an
2,500?
increased bond is warranted. They're making fake IDs, they're changing mailing addresses. He has the equipment to make these cards. They recovered a significant amount of money. There may be other victims. Additionally, I believe they found several other bank cards, and also I think there was information with it says a composite notebook, multiple personal identification information, including people's social security numbers.
Judge, I see no prior history for Mr. Robinson.
Yeah, I know.
I would ask if you would consider a reduction in the bond. If they file other charges in the future, then obviously they'll be addressed by the.
This is what I'm gonna do, I'm not lowering the bond, I think this is a terrible crime against poor people that don't know, having their personal information stolen, and then they have to jump through hoops to try and reinstate their credit because of these actions, besides all the businesses that are losing money. So I'm gonna leave the bonds as is, I'm not gonna raise it, it'll be $2,500 count 1, $2,500 count 2, $2,500 count 3, $2,500 count 4, $7,500 count 5, $2,500 count 6, $2,500 count 7. So that's 10, I think the total bond is $22,500. That's plus a Nebia requirement. You have to show the money used to post your bond is from a legitimate source of funds. If you're unable to post a bond, you'll have to revisit it with the division judge. It's Judge Venzer. Okay, good day.
If I post the bond today, he'll be able to get out today.
Nope, you got to show that he's not getting out for a few days. Got to prove the money being used for the bond is legitimate. It's not from the proceeds from any illegal activity he was involved with. So you can you can get your bank records together to show it to the division judge. It would be Judge Venzer. You can call her office to set it up. Call the public defender's office, they can assist you. Corrections I'm sorry, I can't do anything alone.
So thank you, Grandma TCF, for throwing down 10 gift memberships. That did indeed bring us up to 100, and we're not even a half an hour into this show. Seriously, you guys are absolutely amazing. Beth and I were just chatting back and forth. I'm still in awe at what I've stumbled into, and we're not even quite at a year yet. A few days away from being a year old, and this is the best thing ever. So thanks again to all of you. Judge Stevens, let's go there.
I was unsure before we had the document.
What's on your shoulder? What is that on your shoulder? It's a device, huh? What do you do over there?
Process operator.
Process operator. Okay, let's see. This looks like an analysis. 2 cases, as you know, these are $32 and $33. Just 1 second.
Okay. This one. Sure. You're good.
Looks like the same event.
Yes, yes, sir. Same transaction.
Okay, well, this is an announcement, and you understand you were charged here with a third-degree felony of evading detention. And apparently it alleges that the complainant in this case suffered serious bodily injury. So it's a third-degree felony, which carries with it up to 10 years in prison. The other one's not any better, but much worse, escape, which is a first-degree felony, the way it is alleged, which carries with it no less than 5, no more than 99 years confinement or life imprisonment. And fines up to $10,000 can also be assessed in each of these. Okay, these were both handed up on January 15th of this year. What are we going to do?
Judge, I've been speaking with the state throughout the last vote. We've had some communication issues, but I think we've resolved those. We're trying to get matters resolved. There was a discovery issue that we got resolved last week, so we're talking. It's the best way I can describe it. This.
Okay, that doesn't help me. I move forward. And that's, once again, it'll be October next week. And this one hasn't been rolling around since the beginning of the year. So how much time do you need for a decision?
It's always part of it was based on the conversation.
I'm gonna give you 3 weeks.
Can we have a month, Judge?
I think we'll be able to discuss it
We
next week.
I heard a whisper over there.
You've got a gap. I believe it's 3 weeks.
Did I know about that?
Yeah.
Or did y'all have some kind of a sinister plan afoot? 4 weeks, good, okay?
Yes, sir.
Yes, sir.
Oh, thank you.
Francisco Torres is Ryan Gerst. Francisco Torres, are you here? That you? Okay. Have you talked to your attorney today?
No.
Okay.
He's running late, he'll be here.
Just confirm.
That's a false statement. He is not running late. I've never seen Ryan run. I'm not sure he can run, but because I know him from way back. Carly Fowler. Carly Fowler once.
She might be in federal custody. This was a dismissal.
Carly Fowler twice.
I think she might be in the back, Your Honor.
She's in custody.
They said, is there a dismissal on the tablet?
Yes, I have to hand it over to you. Oh, sorry.
Thank
you. She'd been in federal custody.
Who wants a dismissal on this?
Well, I don't.
That's a no. Thank you. He who hesitates is lost, right? What is it? Can I talk you into it?
I'm gonna say yes.
Yeah, I did. You want one? I got 2 of them. Okay, Carly Fowler, is that you?
Yes, sir.
24 CR 1990. You were charged with the first-degree felony of aggravated robbery, which carries with it up to life in prison. I'm about to dismiss this case.
Really?
Does that make you feel better?
For real? Oh, that's so great.
Well,
Oh, thank
only because it's apparently the right thing to do.
Thank
The
you.
question is, how did you get I don't want an answer, but how do you get yourself into something like this, And I think, have you learned a lesson out of this whole scenario? Valuable lessons that
Yes,
you
sir.
will use in the future
Yes, sir.
in making judgments. Okay. I'm sorry, I didn't ask you. Is this okay with you?
I'm gonna say yes, Your Honor.
that your final answer?
That's my final answer. I'm happy to call us teammates.
The case is dismissed. I mean, it's obviously a serious matter, and I don't know how you got into this, but you're getting out of it. But hopefully it made you a wiser person
Yes,
in the way of decision making. Okay, that's done.
Thank you all very much.
Uh, Taylor Jackson. I think that's yours too. Is that right? Yeah. Two cases. I don't see dismissals on these.
No, sir, Your Honor. We are, Ms. Sarah was the prosecutor. Last night we were here. The court was giving me an opportunity to go and seal the certified juvenile records. I've been in touch with Mr. Nelson. I really need to file a motion for that. There were loose standings. And so I'm respectfully requesting one more.
He's got 6 cases total.
I have 4 in mind.
Just 4?
Yes, please.
Anyway.
2 incidents complaining witness.
You might not have the new one.
Is there a new one?
All right, I have 2260, 2261, 2262. And in sequence 2263.
25.
Not with,
Oh, yes, it's a UUMV. He is a state jail.
That's right. That's official.
00.
it's not.
Might just be out of order. If not, I'll print it out.
Still using a numerical sequence method on.
Yes, there we go.
Forgot about the page. It's not important in my office. So.
Taylor. Taylor. Okay. Hey, Ellie. Thank you. Because I think I fixed the problem here. Need 5. Six 2260 61 62 63 and 77,
I believe 7-7 is the new one.
which is unauthorized use of a motor vehicle.
Correct,
Okay,
yes.
Yeah, it was in here. It was just. Okay. These are all.
Hear me?
It doesn't get much more serious than this.
Yes, sir.
And these are 4 aggravated sexual assaults of it looks like 4 charges involving 2 separate children.
Yes, all juvenile children,
Is that right?
Yes, Your Honor.
including the defendant.
And then the other one is unauthorized use of an oil vehicle, which I guess is state jail felony. It is. So what did you say?
Your Honor, last time we were here, the court was allowing me a reset to try and go ahead and get the certification records because our client was a juvenile at the time of this. I did attempt to get those records. That was blocked by the district clerk's office. I talked with Mr. Nelson. Mr. Nelson has advised me that, of course, I don't think there can be an opposition, but he would not be opposed for me to file a motion to unseal the certified certification procedure in this particular case. Along with that, I've had some attempts to reach with Sarah, but my mother-in-law went in the hospital and came out of the hospital and got COVID from the hospital. So it's been a little dicey for me since that time. I'm respectfully requesting another continuance announcement to go ahead and do the unseal and to get with Sarah, although I think in this case may be transferred to another ADA.
Stand by. Looking at the dates of all this, so
Yes, Your Honor.
these were two children, 8 and 11 years of age. And then the defendant looks like he was 15.
He ranged from
At one-
13 to 16 in the offense dates. The children ranged from 7 to 8 in the offense dates.
The defendant's birthday is in May of 03.
Correct.
So December 11th of 18 would have been 15. And he would have been 15 in 262, December 11th, 2019, he would have been 16.
Yes, I think there are some offenses that are not alleged in the indictment. But,
Well, I'm only guess.
right,
And then 2263, December 14th, 2019, 16 then. And then two 6-2 was 15. Okay. In 2 instances, he was 16, and 2 he was 15.
I believe so, Your Honor.
All right, and there's not an issue about age on the unauthorized. He was an adult during the unauthorized use of a motor vehicle.
Yes, sir.
These were all indicted October of last year, right?
Correct, Your Honor. I believe he had a different defense attorney for quite a while.
All right. And these are all first-degree felonies, which would generally carry with it up to life in prison.
Yes.
In each case. And then the unauthorized use of a motor vehicle is up to 2 years. in the state yet today. What do you want to do?
Your Honor, I'm respectfully requesting one more announcement.
How much time?
Would the court allow me 60 days in this to get to deal with the sealed records, which I didn't anticipate a block from the district clerk like I got, but at the end of the day.
I'll give you 6 weeks. Let's see where we are then, okay? 6 weeks. Let's try to meet it at 6.
Yes, sir. Thank you, Your Honor.
I'll give you a reasonable amount of time.
Yes, sir.
Brian, it's easier for you to get here.
All right, everybody, let's switch it up and get away from Barbara's most hated judge. And in our efforts to have 9 to 11% more Judge Boyd, let's go there.
All right, so before we go on the record, my understanding is that with Judge Angeline, he had entered pleas of truth,
That's correct, Judge.
and then he was to come back for the outcome of something.
Of a UA. And so he had some food poisoning that day. He'd gone to
Oh, but let's get the
pre-trial.
record.
Okay, we can do that. Like,
All right.
it's a little bit of procedural.
I was just trying to figure out.
Yeah, there's a story.
Okay. All right, the court is calling 2022 CR 1449W State versus Austin Young. Can I have parties announced for the record for the state?
Lauren Espinoza.
Defense?
Louis Martinez on behalf of Mr. Young.
And are you Mr. Young?
Yes, ma'am.
All right, on September, I think this is September 11th. You
Yes,
entered a
ma'am.
plea of true to violations 2, 2, and 2. And there was no sentencing on the plea. Off the record, your attorney informed me that you were requested to do a UA or something.
A UA,
Yes.
the 11th.
All right, you may proceed to counsel.
Okay, so Judge, just procedurally. So on the 11th, Mr. Young was released by Judge Angelini, provided to go to get UA. And essentially told him in open court, if you clean tomorrow, then, you're just going back on probation. I'll reinstate you. If you're dirty, then you need to go in someplace. Mr. Young called me from pretrial services. I was on the phone with him. We were trying to talk to somebody there about him doing a UA. They kept saying, we don't have anything from the court, so we had trouble doing that. The next morning, Mr. Young had some food poisoning issues, had been at the doctor's, did not come in, a warrant was issued. And then we just tried to regroup and figure out where to go from here. And so Mr. Young brought himself in voluntarily yesterday. One of the things that we needed to address, that we'd addressed with the court, with Judge Angelini, is that in May, Mr. Young was having some mental health issues and some kind of mental health emergencies. And that was kind of the reason for the non-compliance in May. I've got his mother here to testify to that. And so I'd ask the court for to allow me to bring her up and kind of explain what was going on. Okay.
You just step over there.
Yeah.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Wendy Scholimer,
All right, and can you spell your last name for the court reporter?
SCHORLEMER.
All right, defense, you may proceed.
Ms. Scholimer, obviously you're Austin's mother.
Mhm.
Can you explain to the court what was going on with him mentally in May and what our issues were?
He had, looking back, shown signs of depression, but I didn't know that's what it was. He was not eating a lot, not active. He had a lack of energy, in bed a lot, depressed. He was looking for jobs and getting no luck at all.
Okay, let me stop you there. So he was looking for employment. And obviously, the biggest issue is his criminal history.
Yes,
Okay.
the record.
Right.
Nobody wants to even open the door to him.
Okay. And what effect were you seeing on him mentally?
He, looking back, was completely withdrawing and kind of having a mental breakdown.
What kind of signs did you see of him having a mental breakdown?
Withdrawn from everybody.
Okay. Did you seek out any kind of medical help from at the time?
Yes.
And what kind of mental help did you seek out for him?
I took him on Sunday. Friday was when I really noticed something was not right with him. He was kind of talking, saying crazy things, not crazy, but just not appropriate things, not in the here and now. And so on Sunday, he was not sleeping either, not eating, not sleeping. So on Sunday night, I ran him up to a little local ER, Methodist ER in our neighborhood.
Okay.
And they did a history, and not a physical, but just talked to him, this cool doctor from Austin, and said, well, maybe you just need to get some sleep. And I was very shocked at the lack of care or concern, but of course I'm his mother. So he said, well, let me give you something to sleep. So he gave him one Ativan. And by the time we got to the car, he was relaxed and he slept that night.
Yeah.
Monday morning, he woke up and became very agitated and talking out of his mind and not eating and just not himself. So then that went on Monday. Monday, we came down to see you.
Yes.
Because I knew he had court Tuesday, and I knew he couldn't do it. He wasn't sleeping. He couldn't get dressed. He was a mess. So Tuesday, I took him back. I went to a Stone Oak Methodist Hospital ER.
Okay.
And we waited for hours. And kind of the same thing, a little bit more concerned, but not much. And we sat in a room for hours, and the doctor did do some blood work. No blood work, did a urinalysis. And then they gave him something, and it made him much worse, much more agitated. At that time, they called in a Bexar County, I guess, policeman or sheriff. I'm not sure who he was, but he was very kind. And he talked to Austin and said, they don't have the facilities here. They don't treat psychiatric patients, but we can just take you in the ER and the ambulance straight over to Methodist Specialty where they can help you.
Okay, and let me stop you. And so was he taken over to Methodist Specialty?
No.
Okay.
He said, no, I'm fine. He said, I'm fine. I said, no. I looked at the policeman. I said, no, he's not. And he said, well, we can't force him to go, and you can't either. He's an adult. So they gave him something, made him, I said, he's got to have something to sleep. I can't take him home. He's pacing the floors 24/7. So they gave him one more Ativan. And I said, could you please write him a prescription for just 2 or 3 until we can get to see a doctor? And she said, no, you have to go to Methodist Specialty. We are not a psychiatric hospital.
Okay, let me stop you there. And it's kind of subsequent to that is when we started coming to court, and we've had these, the issues with the warrant, those sorts of things.
Yes.
Okay.
Yes. And then
And so
that's yet to come.
okay. Now, had you ever noticed him have kind of a psychological breakdown like that before?
Yes, once before
And when was that?
in high school.
And what were the circumstances of that?
He was having a very difficult time getting through a math class that was required for graduation. He had lots of learning disabilities, and he was being bullied, and all of a sudden just stopped eating, wouldn't go to school, completely shut down.
Okay. And the situation seems to be kind of consistent with that.
Yes, but the pediatrician at that point helped us and gave us something to get him through it. And with the principal's help and the special education department's help, we were able to get him out of the high school and into a alternative school to finish his requirements to graduate
Okay,
early.
okay. And so these are the issues that he's been having for the past several months,
Mhm.
correct?
Yes,
Okay. And a lot of it is the fact that he's trying to move forward and he's kind of running into roadblocks every chance.
yes, he can't, he's getting through his probation pretty well in his recovery program, but he can't be a productive young man. He cannot get a job.
And you see the stress that puts on him.
Oh, yes.
Okay.
I mean, one day he said, Mom, there's no hope for me. I might as well just end my life.
I'll pass the witness.
Any questions?
Briefly, Your Honor. Hello, Mrs. You stated you observed these types of signs prior to May 25. Is that correct?
Yes.
Approximately what year was the high school incident?
Oh, when he was, let's see, I guess about 18.
And he is how old now?
I'm sorry,
How old is your son now?
39.
So how many years would that have been? About more than 10?
Yeah.
Okay. To your knowledge, did Mr. Young ever acknowledge these signs that you observed in him?
Did he acknowledge?
Mm-hmm.
No.
Okay.
He said, Mom, I'm fine, I'm fine, I'm fine.
And is that in both 2025 and when he was in high school?
I don't remember high school.
Okay. To your knowledge, did Mr. Young inform his probation officer?
You work
of these
as
issues
much
he was
as you're
having?
at home,
Uh-huh.
and that wherever you
Yes.
are, you should
Okay.
try to
He
make it
talked
as
to him
beautiful as
numerous
possible.
times about the
Well,
issues
that
of
works.
employment. He said
So
that
you
you're
were
able to
looking
go to
behind you, and
Goodwill.
then you
But I'm
say,
speaking of the mental health.
Oh, yeah.
issues.
I think so. And he discussed, maybe he informed him that he was on an antidepressant.
Mhm. But you're not positive of that, or you are?
No, I'm not.
Were you aware of Mr. Young being on probation?
Yes.
Yes. Were you aware that one of his conditions is to submit to drug testing?
Yes.
Were you aware that he violated that condition?
Yes.
Would you agree with me that the best way for someone to learn a lesson is to take accountability for their actions?
Yes.
No further questions, Your Honor.
And just very briefly, Austin still is on a alcohol monitoring device, correct?
Yes.
And he's on probation for DWI. He does not drive anymore.
No, does not have a car and does not drive anywhere.
Okay, so he gets rides or Ubers or
For
walks.
me,
Right. Okay. And so, to the best of your knowledge, he is not picking up new offenses, correct?
No.
And to the best of your knowledge, he's reporting to probation.
Yes. I know that he missed one time
Okay.
on a Thursday afternoon.
Yes, ma'am. I'll pass the witness.
all right, thank you so much for coming down. Thank you. All right, so here's the court's issues.
Okay.
One, this is not his first motion to revoke,
Correct.
and it's not his first motion to revoke for violation of condition number 2. And it seems every time there is an issue with probation or there is a potential revocation, he doesn't show for court. And something else has popped up where he can't show. And it appears that his issues are the consequences. So I don't know if there's a reason to continue him on probation, because I don't know if there's anything that we can do to help him.
Judge, I'd like him to UA today if the court would do that. I would, obviously there's some mental health issues. Obviously he's struggling, but I think that the main, there's a lot of things that we ask people to do on probation, but I think the two main things we ask them to do is not break the law anymore and to report and allow themselves to be supervised. And he certainly has been doing both of those things. Our biggest issue when we get DWIs in felony court is the fact that it's not your first DWI.
Mhm.
By definition, it's not. And if you're willing to get 3 DWIs, then, there's an issue. And I think that the most, important thing he's done for accountability is just decide never to drive again. And that's good. That keeps the community safe. So the issue now becomes, how much work do we want to put into him, right? Because, we've got some compliance here, and I think we've got substantial compliance. But if our question is how much more help can we give him? I think that we can. I think that he benefits from the structure. I think he benefits from the supervision. I think he allows himself to be supervised. But, it's not easy to be on probation. It's not easy in this society to have a criminal history because you don't get the same chances other people do. And I'd ask the court to consider a sanction other than revocation. I'd ask the court to consider, there's a recommendation for state ISF cognitive track.
Hasn't he been in a facility?
I think
before?
he's been to SATF before, but I mean, we're talking about some cognitive skills. And the main thing is we need to put him in a position to work. And I think like with most people, if he's working, we're not going to have problems with him showing up to court. We're not going to have problems with him showing up to probation. If he's working and he's productive, I think that we're going to get, if not perfect compliance, then pretty close to it. Because he's not a person who is out breaking the law more. He's not a person who is refusing to go to probation. And, in fact, as the court knows, he came in yesterday. He knew he had a warrant. He knew he had missed. He knew this was an issue. And it's not like he went ahead and hid out until he got picked up. He came in to take accountability, to go head on and face his actions. And we know that this court is really good about trying to craft conditions of probation that help a person be successful. And so I'm asking the court to consider that in this case.
All right, state.
Your Honor, the state echoes what the court sentiment that this is not the first MTR or violation of condition number 2. There is consistency in failing to take accountability. We'd ask that you'd grant the state's recommendation to revoke. Mr. Young was given opportunities to comply with probation and take full accountability, but we would urge that partial accountability is insufficient here. He was explained his conditions of probation, and he has shown that through his actions in subsequent violations and then subsequent FTAs on 9/12 and 9/23 that he's still not taking accountability for his actions. So we'd ask that you grant the revocation.
All right. This is what the court is going to do. The court is going to revoke. The court will sentence you to 3 years in the prison, give you credit for any time served, 2-year license suspension. I'll request the therapeutic community. There's a $1,500 fine, time and money to run concurrent. I'll give him credit for any successful completion and inpatient treatment.
Okay.
And let me see. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
The form that we signed when Judge Angelini was here, did you review that form with me when you signed?
It's the form
Yes.
telling you whether or not you have a right to appeal. You do have a right to, you have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you can speak to an attorney. Do you understand?
Yes.
All right. So we can go off the record. So Mr. Young, it's just that the court has worked with you by giving you inpatient treatment and giving you different treatments to try to help you. But at some point, there is nothing else that I can do. I don't have any more tools. It's sad that the legislature doesn't have more to offer, but I have what I have, and that's it. So you'll receive the credit for any time that you've served, okay?
And
Thank you.
would you allow him to say anything to the court right now?
I'm sorry?
Judge, would you allow him to say anything to the court right now?
Sure.
You want to say something, Judge?
I don't know what to say, Liz. I'm shocked. I've done everything. I've finished all my probation stuff. I was just waiting for my, my probation to be finished. I've done all my classes, paid for fine. I've done everything. The only reason I had another MTR is that we had lost the monitor and I couldn't afford to pay the $3,500 and you gave me this
So
thing
here's the
for
problem.
90 days and it's been
This is
over
the
a
problem.
year.
This is the problem that you're not understanding. You had a violation of condition number 2 previously with the court. You pled true to it. I found it true. And I gave you conditions to address that violation. And then you come back and you have the same violations. So when you have the same violations, which were violations of condition number 2, we have nothing else. Thank you, counsel. Yes. Are you here? Because I have to go.
Okie dokie. We'll stay in Texas. Go back to Judge Stevens.
Okay, you're Mr. Koenig?
Yes, sir.
And Mr. Lane is here. You were charged here in 24 CR 2327 burglary of a building, which is a state jail felony. However, the indictment also alleges you have 2 prior state jail convictions, one out of Liberty County in 2017 and another out of Liberty County in 2021, which does that enhance this to a 3rd-degree felony?
Yes, sir.
That's correct,
Mhm.
Judge.
So you're looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. If these felonies are accurately alleged, you are not eligible for probation in front of a jury. So it's all or nothing in front of a jury.
Yes, sir.
What are you going to do today?
Your Honor, I've not had a chance really to talk with the state's attorney. Last time we were here was our first announcement. We do have discovery in this case. I've gone over with Mr. Koenig, but if the court would just allow me one more announcement, I could talk with the state's attorney and see where we're headed.
Actually, this was the 5th announcement.
Really?
Oh, yeah. We have one here that was on February 4th. And then the next one is on May 19th. And the next one is August 5th.
Oh, well.
And then August 7th, something must have happened where you asked for some additional time.
Yes, sir.
And then August 13th. And then here we are today in September. So, I mean, we've been, the announcements began in February. So,
I apologize.
Okay.
Last time.
What can you do about it?
I was here. 30 days.
Yeah, 4 weeks.
Thank you.
4 weeks. Okay. Where are we on? Is there something working?
Your Honor, there was an offer made by Daniel who had this case before me. At this point, the offer remains the same. We can discuss what that is.
Hey, guys, no texting. I'm just kidding you. Don't get me.
We're texting each other.
I'm just texting each other. Can I get in that loop?
Right, thank you, Your Honor.
I just like it. Those guys are working on things. You know, they got, everybody's got schedules. That's like that because everybody's busy.
Yeah.
Yes, sir.
So 4 weeks good
Yes, sir.
on it? Okay, Brian, thank you. I've got Darren Porter. Hey, Brian. Darren Porter is next. Thank you. And then Brandon Richards after that, and then you're done.
Yes, sir.
By the way, I've got a Evan Bond dismissal before the court, so I'm signing that, whoever's on that one. Thank you.
I see $25.
That's been dismissed. And that one, Carly Fowler, that's both been dismissed. On Darren Porter, that's you, sir?
Yes, sir.
25 CR 335, you're charged with a second degree felony of burglary of a habitation, but it doesn't end there, as you know. You got 2 prior convictions that are alleged, which are serious. One is a second degree felony burglary in 89 out of the court next door. 252nd, then also out of the 252nd after that conviction in 1989 of burglary of a building was final. It was in the old days when it wasn't a state jail felony. It was a second degree felony in the old days. Then the defendant is alleged to have committed assault of a child and convicted in that court in 2005. So what we have here is habitual felon status. You're looking at no less than 25 years to life imprisonment. Do you understand? Serious, as serious as it gets next to capital cases. All right. It's been around a while. What are we going to do? And again, here, this is one of those where you're not eligible for probation in front of a jury if you went to trial. So it's pretty much all or nothing there in front of a jury. Okay. Yeah, we've been getting resetting since May. So what are we going to do?
We've been made an offer from the state. We will respectfully ask that this be placed on the trial.
It's set for trial. And how long can everybody be ready? Please.
Judge.
We're going to put this quickly. Okay.
Thank you.
Set for trial. And please get ready. Brandon Richards.
So while he brings up the next contestant, it's time for a choose your own adventure. We can stick with stuff like this, or Judge Wolf is about to do a sentencing for somebody who was found guilty on a second-degree murder. It looks like they're bringing up a bunch of people on that. It's probably going to take a little bit, but it could be intriguing. If that's something you want to do, drop a 1 in the chat. We'll see how many 1s we get, and that'll determine whether or not we do it.
Okay, what are you going to do on this one? It's a Fisher cut bait day.
Yes, sir. Well, we're respectfully placing this on the trial docket.
Okay. You're looking at up to 10 years in prison. Does he have prior? You know?
No,
Sure, I don't think so. Okay. Gonzalo Alvarado. Gonzalo Alvarado, please.
Okay. Morning, Judge. Rather, this is not an expert in motion. Mr. Hughes, the prosecutor on this case. I don't know if you want. Yes.
You're retained on this though, right?
That is correct.
Well,
If you right on top that he just filed.
Hmm.
You filed something this morning. I have it on top for you to peruse.
The judge, again, assistance in its party.
I understand. Is that all we're doing today, dealing with this?
This is it, Judge.
Okay, stand by. Let me get the other stuff and then we'll.
Yes, sir.
Yes, sir.
Thank you.
And Sabra Shivers. The Shivers. Mr. Gasper is Do you have an attorney? Gasper? Is Mr. Gasper your attorney?
I'm not sure.
Oh, that's the state's attorney. Oh, it's kind of.
She's not here.
Is anybody here for the state otherwise?
She's right
You up there,
Saber?
sir?
Oh, thank
there.
The MTRP status review, right?
I believe so, yes.
I reached out to her.
So she's not here?
Don't.
Saber? Sabra Adriana Shivers. Sabra Adriana Shivers or Shivers. There is no answer in the courtroom. I ask the bailiff to call into the hall for Sabra Adriana Shivers. Please. I sense something's amiss. When was the last time? Has she failed to report? Really? She knew to be here?
I reached out to her yesterday. No response, Sean. She didn't answer the phone. I contacted food sources. They did not answer it either. She did respond to an email that I received this morning. Stating that she had a new phone number. And that she was not aware of the court taking it.
Well, she's aware. Who said she's not aware of the court date?
She said she was.
When did she say that?
I received an email this morning.
Oh, but she's aware. How could she not be aware? She's telling you she wasn't aware, which means she's now aware of it, right? Okay, well, she didn't appear. A warrant is issued for her arrest. That's all we can do. She's on regular probation. That's a conviction, and a warrant shall be issued for her arrest.
The restore without warnings.
Now I've got a warrant for him. And
All right, well, that's obviously got an unfortunate ending for the person who did not show up. Not much feedback from you guys, but let's go ahead and do this. We're going to go to the great state of Tennessee. We'll spend some time with Judge Wolf. Again, this is a defendant who was convicted second-degree murder, and this is his sentencing, and I believe they're going to have some people testify.
All right, is the state ready? Defense ready? All right. You may call your first witness. Step right around here, please, ma'am. Clerk here will raise, if you'll raise your right hand, she'll place you under oath.
Good morning. There's a microphone, yeah. If you can speak directly into it, thank you. Will you state your full name for the record, please?
Penny Allen Williamson,
Thank you. Will you spell your last name?
Williamson.
Thank you. And will you tell us your relationship to Mr. Jordan Knight?
He's my youngest son.
Your youngest son? Okay. And Ms. Williamson, as you know, we're here today for the sentencing hearing, and I think this is the opportunity in which you may give your victim statement.
Okay. On October 5th of 2020, we lost our youngest son. On that day, my family and everyone that loved Jordan was given a life sentence. A sentence of sadness, heartbreak, emptiness, and will never be healed. A life sentence of memories that will never be made, words that will never be spoken. Jordan Blake Knight was a loving father, brother, and son. He was so kind-hearted and always wanted everyone to be happy. He is missed more than words can express. Curtis Day, I don't know anything about you or what type of person you are. I don't know if you care or if you even are listening to my words right now. But I look around and I see your family, I saw them at the last hearing, and I see them today, and I see the pain in their eyes as well. And for them, I am sad because I know they're feeling a loss as well. I want to say that I forgive you. I forgive you because that's what my Savior, Jesus Christ, has written needs to be done. I have no hatred for you in my heart, only sadness. I am sad for everyone involved in this. Bad choices are made and lives are destroyed. I pray for you and your family during this difficult time, and I pray that you find the opportunity to have a relationship with Jesus Christ and to ask for his forgiveness, because his forgiveness is much greater than mine.
Thank you very much. You can step down.
Grouch, you may call your next witness.
State calls Miss Wendy James. Good morning.
Morning.
We state your full name, please,
Wendy James,
and spell your last name.
James,
Miss James, where are you employed?
with Tennessee Department of Correction, probation parole.
And were you asked to, or did you receive a court order to prepare a pre-sentence report in this case?
Yes, I did.
And which defendant is the report prepared for?
Curtis Dale Day.
And have you filed a copy of your pre-sentence report with the Cheatham County Court Clerk?
Yes.
Thanks. Excuse me. Ms. James, in preparing the report, were you able to take a comment or statement from the defendant?
Yes.
And has that been listed out in your report?
Yes.
Will you turn to that page, please? I am looking what I believe has been marked as page 3 of the pre-sentence report. Is that correct?
Yes.
And on that, is there a defendant's version that you recorded?
Yes.
And will you please read that for us?
During an interview with the defendant on August 7th, 2025, the following information was obtained. The defendant indicated he was selling drugs at the time of the incident, but that he never sold drugs to the victim in this case. He reported he never met with the victim and never spoke with the victim. He reported he was dealing with a female, Amanda Gober, and that she sold drugs to someone who gave the drugs to someone else, and that person overdosed and died. He reported he isn't even sure if the drugs Amanda had were the ones that he had received or she had received from him, because she could have been buying them from other people. He did admit to selling drugs, but could not confirm or deny that the drugs that killed the victim were the drugs that he sold.
Thank you. In preparing the report, did you have an opportunity to review the defendant's prior convictions?
Yes.
And will you turn to that page, please? Are we looking at page 4 of the pre-sentence report?
Yes.
And what convictions did you note that Mr. Day has?
He has 4 meth convictions.
Okay, and starting with the first one, what is the offense date?
12/2 of 2022.
And was that conviction out of the United States District Court?
Yes.
So a federal court?
Yes.
And it was for methamphetamines, sale, manufacturing, delivery, sale, or possession?
Yes.
And what was his sentence?
5 years.
And the second conviction, was that on November the 9th? Excuse me, not conviction, but what was the offense date for the second conviction?
11/9/2022.
What was the sentence?
5 years.
The third offense?
10/19/22, meth, 5 years.
And the fourth offense?
It was 10/5/22, and that was another meth for 5 years.
So there were 4 separate offense dates?
Yes.
And the defendant was convicted on all 4 of those counts?
Yes.
And that was in the United States Federal Court?
Yes.
And he was sentenced to 5 years?
Yes.
Were those 5 years concurrent with each other?
Concurrent, yes.
Were you able to find any other criminal history on the defendant?
There was one other offense, date 5/16 of 2012, casual exchange, a misdemeanor. He received a 6-month suspended sentence.
Your Honor, may I approach the witness?
You may.
Ms. James, can you identify the document that I just handed to you?
This is the pre-sentence investigation form that I completed and filed.
Thank you. And Your Honor, I'd ask that the pre-sentence investigative report be marked as Exhibit 1 in this hearing.
Mark it as Exhibit 1.
I will pass the witness.
Mr. Atchison, may cross-examine.
Good morning, Ms. James.
Good morning.
Now, we've already established the fact that you were the one that prepared this report, correct?
Yes.
Now, as it relates to those convictions that were just mentioned, were you also provided with the report on that particular case?
Yes.
And Ms. James, you're also aware that this was all the same case, correct?
Yes, they were separate counts, same case.
Separate counts, same
Yes.
case. And as part of that report that you received on this federal case, this was, according to the report that you received and reviewed, this was an instance where agents used a confidential source in order to get these different dates, these different cell dates on these charges, correct?
Yes.
Now, outside of that case, you mentioned the only other thing that Mr. Day has in his history is a simple possession charge.
Yes.
Is that in 2012, correct?
Yes.
Now, did Mr. Day participate in this interview for the completion of this
Yes.
probation report? Is it your experience that defendants normally participate in the interview portion of this?
The majority of the time, yes.
And based on your report, you conduct what's called a strong R assessment, correct?
Yes.
Can you explain to the court where Mr. Day falls in accordance to that strong R assessment?
He scored moderate, which is in the middle.
And moderate
risk for reoffending.
And just for purposes of clarification, what does moderate range generally entail as far as the recommendations?
Recommendations usually include programming, whether he serves prison time or on probation. It's different programs we recommend based off of the score.
Would those be cognitive behavior type
Yes.
recommendations or
Victim
courses?
impact, cognitive, behavioral, alcohol and drug, mental health, just whatever he needs.
And during your interview with Mr. Day, did he appear honest in his answers?
Yes.
That's all I have, Judge.
Any redirect? Thank you, Mr. James. You may step down and have a seat in the courtroom. Call your next witness. We won't ask you once you're placed under oath. I'm not going to ask you how fast you drove from Ashland City to here. So.
Good morning.
Good morning.
Thank you for being here. Lieutenant, will you state your full name, please?
It is Shannon Heflin,
And will you spell your last name?
Heflin.
Thank you. Lieutenant Heflin, you were a primary witness at the trial in this case, is that correct?
That is correct.
And you were the lead investigator or one of the investigators assigned to the death investigation of Mr. Jordan Knight.
Yes, that is correct.
You also, as I've already said, testified at trial.
I did, yes.
There were some questions that we could not ask at trial that I'd like to follow up on now at the sentencing hearing.
Okay.
Aside from the death investigation, were you a part of a group or team or task force that made some controlled drug buys from the defendant?
Yes, I was.
And you've heard the testimony of Miss Wendy James. The defendant was convicted on those controlled buys. Is that correct?
That is correct.
I want to ask you just a few details about those purchases. How was that set up?
I guess we'll just start from the beginning. We reached out to some of our federal analysts and give them some of the phone numbers that we had and some of the names that we had involved, just trying to make a case on the overdose death of Jordan Knight. Probably a few weeks later, after getting that information entered into the federal database, we were contacted by the FBI out of Cookeville, Tennessee, and they had some interest in the suspect's name of Curtis Day in relation to a burglary theft case that had occurred out in East Tennessee, where some of the guns had reportedly made its way back to Day's residence on Germantown Hill.
Okay. From that, with that information, were you able to send a confidential informant into Mr. Day's residence?
Yes, we were able to come up with a confidential source. We introduced them to the FBI, and at that time we decided to go in and do some controlled buys.
Controlled buys were at Mr. Day's residence in Davidson County?
That is correct.
And it's the same residence that we heard testimony about in the trial?
Yes, that is correct.
Off of, is it Clarksville Pike?
Germantown Hill, Clarksville Pike, yeah.
Thank you. I believe it was trailer unit number 13.
I believe that's correct.
So the controlled purchases or controlled buys occurred in the same place in which drugs were sold to Mr. Jordan Knight?
That is correct.
We've also heard the name Amanda Gober.
That is correct.
Amanda Gober was living with the defendant at the time of Jordan Knight's death, is that right?
That is right.
Was she still living with Mr. Day at the time these controlled purchases were made?
Not at that time.
When the controlled purchases were made, was this done over a series of a couple of months?
Yes, there was, I think, maybe a total of 4 buys, controlled buys done.
And do you recall what type of drug was purchased?
Methamphetamine, crystal meth.
Methamphetamine. And were these purchases made directly from the defendant, Curtis Day?
They were all recorded on audio.
They were recorded in audio?
Yes.
And it was the defendant, Curtis Day?
Yes.
All right, thank you. I'll pass the witness.
Mr. Atchison, you have questions?
Morning, Lieutenant.
Good morning.
I'm going to get it right this time. I think I messed it up a few times during the
You
trial.
can call me Captain.
Now, again, just to reiterate, you testified during the trial in this matter, correct?
That is correct.
And you're well aware of the facts surrounding this case and also what was presented at trial, correct?
That is correct.
Now, you testified there were 4 separate controlled buys, correct?
That's my understanding, yes.
Out of those 4 controlled buys, were the drugs that were obtained during those controlled buys, were they tested?
After the control buys, all that was turned over to the FBI, so I don't think I can accurately testify that it was. I'm assuming that it was. I could sit here and assume that it was, but I wouldn't be able to answer that question 100% positive. I'm going to assume that it was.
That would lead to my next question, which, based on that answer, you would have no knowledge whether or not those drugs tested positive for or contained fentanyl.
That is correct. I would not know that.
Now, these buys did occur in Davidson County, correct?
That is correct.
Which is exactly the same location where the buy in this case took place, correct?
Can you repeat that?
Those controlled buys took place in Davidson County, correct?
Correct, yes.
Which is the same, in this case, the buy or the transaction in Mr. Day's case occurred at the same location in Davidson County.
That is correct.
Now, General mentioned Ms. Gober, and she testified to it as well, that she had resided with Mr. Day, correct?
That is correct.
Now, when these buys took place, it was your testimony that she did not reside there. Is that correct?
During the buys with the feds, the
Yes.
FBI, no, she did not.
Was that based on the fact that she was incarcerated at that time?
I'm not sure if she was incarcerated or in the drug court program. I'm not too exactly sure where she was at that time.
But she was charged also in this case with Mr.
That
Day.
is correct, she was.
Lieutenant, at any point in time during the investigation, was Mr. Day interviewed by law enforcement for this case?
Briefly, maybe after the traffic stop, there was probably a brief interview.
Or any questions asked directly in relation to the case you were working with Mr. Knight?
I think that he may have refused to answer those questions at that time.
And you've had the opportunity to review Mr. Day's criminal history as well, correct?
Yes,
And you would agree he has no prior convictions for violent crimes, correct?
correct.
And based on the trial and your investigation in this matter, you're also well aware that there were several inconsistencies with certain testimony. Would that be accurate?
You'd have to explain that a little bit better.
In more specific terms, you recall Tristan Matthews' testimony, correct?
That is correct.
And you would agree with me that there were several inconsistencies in Mr. Matthews' testimony?
I would agree to that.
Based on your
Yes.
conversations with him and
Yes.
your investigation? Judge, I'll pass the witness.
Redirect.
Lieutenant, concerning Tristan Matthews' testimony, Mr. Atchison did a good job of cross-examining him at trial, but there were some things that did not come up that were left out about Tristan Matthews. For example, Tristan Matthews actually had disclosed, and it was noted in a report, that he had tossed some of the drugs that were purchased on the ground on the night of the event.
That is correct.
And that's actually noted in a Cheatham County Sheriff's Office report.
Yes, that's correct.
And Mr. Atchison didn't ask him about that. Thank you.
Recross.
Lieutenant Heflin, at any point in time during your conversations with Mr. Matthews, did he indicate to you that there was ever a second bag or a different drug that was purchased?
He did not.
And so, if in fact his testimony was accurate and the report he initially gave to you, then we have no idea where that second bag of narcotics came from, do we?
No, we do not.
No further questions, Judge.
Anything further? Thank you, Lieutenant. You may step down and have a seat. Call your next witness. State has rested their proof, Mr. Atchison. Do you wish to offer proof at the sentencing level? Okay, if you want to call that witness, then bring him in. You step around here, please. Raise your right hand and face our clerk.
I do.
And Mr. Tanksley, as General Crouch pointed out, there is a microphone if you'll try to speak directly into that. If you would, state your name for the court.
Isaac E. Tanksley Jr. Jr.
Maybe not that close, but that's good. Now, Mr. Tanksley, how do you know Mr. Day?
He is my nephew by marriage, my wife's sister's son.
And just briefly, if you would, tell the court your connection with Mr. Day as far as his upbringing.
Curtis, can you hear?
Yes, sir.
Curtis has spent relatively all his life with us. We actually babysat him at birth, and my wife was very fond and close to him, all of us, from birth to 4 years old. That's when his mother moved to somewhere in that time frame, maybe 6 years old, moved off to California, and me and Lisa stayed connected with Curtis through the years. She was really close to him, like a mother, and I was always right by his side too. But I'm kind of a more tough love type person, so it's our relationship was more manly than it was. I mean, I love Curtis. He's always been a good person, but he's had this demon that he's battled with for his whole life, and we've just kind of stuck by him, and that's what you do with family. And so anyways, we've just always known him. I've known him throughout his whole life when he was from birth until now. I'm here now, so whatever I can answer.
What can you tell the court about Mr. Day's employment history?
Curtis has always been a hard worker. He took a job at a local grocery store in Nashville. I don't know if anybody knows the area, H.G. Hill Groceries. He went there when he was 14, 15 years old and worked there, and off and on with me. I run a tree service, and he's worked with me off and on through the years. And once he got of age, graduated from school, 18, 19 years old, he started doing central heat and air work, and he kind of made that a career. But it was obvious that Curtis had a demon or a monkey on his back, and just sort of dealt with that like a lot of people do throughout the years. And we just sort of loved him and stuck by him, and tried to do what we could to, stand by family. That's what you do.
And as it relates to those demons, can you sort of elaborate a little bit, if you will, for the court? Are we talking about addiction, substance abuse?
Yeah, so I didn't really know exactly what it was and to what extent, but you could tell when there's issues in people's lives, they seem to never have enough money at the end of the day or at the end of the week, and they just they're backwards and withdrawn from social environments. So it's just it was obvious that there was something there, and he worked hard and took raised his family. He took on a family and raised them, and was doing whatever he was doing. And then in 2010, me and my wife were in the flood, and Curtis like I said, he was doing central heat and air work. He come in, helped us out with that, and I could tell that during that time that the drug addiction or abuse had escalated, and it kind of drawn a wedge between me and him with that tough love that I was talking about. He knows that I'm sort of a no-nonsense type person, big heart, but not good patience. So anyways, he helped us through that. And after that deal there with him helping us out with our central heat and air, we kind of lost contact. And the next thing I heard from Curtis was a couple of years later, and he'd kind of hit rock bottom, went through a divorce, and I think that's when he had got that charge. And we didn't know anything about that, but when he come back into our lives full of stream, we could tell there was a problem there. And I took him to the mission and was like, hey, here's the best place I know for you to get help. It wasn't, I think he'd been searching for help and reaching out, and there's not a lot, if you don't have the right resources, there's not a lot there for certain people. So anyways, I took him there, and I was just like, this is the best I can do for you, and give me a call and let me know how it works out. So he went into their life program, spent some time there, got out, went into a halfway house, come back to work for me for several years there. I mean, I guess it was up until the time that he was gone, up until this all happened, he was working for me off and on. But I think he was trying to get himself back into the central heat and air. I mean, tree work is not something that you want to be doing for a career your whole life unless you're just blessed or lucky like I've been. So anyways, I think he was getting back into the central heat and air, and I could tell that he was slipping, and I had talked to him about that. And I don't know if y'all have dealt with that, but it's hard to talk to somebody that's they're just tunnel vision on that addiction, and it's hard to get through to them. All you can do is just pray and love on them and hope there's intervention there.
And during that time, you and your wife continued to support Mr. Day.
Oh yeah, as much as possible. Like I say, that my wife, she's sort of not here today because it's just too much of a drain on her. She just don't have the emotions for it, and it's hard being here. But I talk to him, and it's hard for one grown man to get through to another, especially when you take such a strong stance that I do. It's easier to deny and avoid than it is to just face your demons and work on it. So anyways, yes, I'm always been there for them, and guess I always will.
Is there anything else, Mr. Tanksley, that you'd like the court to know or hear about Mr. Day?
Other than the fact that, we all have issues and problems, and as far as I know, he's always been a good person and just, not really, the picture can be painted a lot of different ways, but he's, he has a lot of good in him. That's all I can say.
I'll pass the witness, Judge.
Thank you, Mr. Tanksley. You may step down. You have anything further, Mr. Atchison? Say you have any rebuttal proof you wish to offer? Then I'll hear you in argument.
I think that Ms. Williamson's testimony and Mr. Tanksley's do an excellent job of reflecting the type of cases that Your Honor and all of us in this courtroom see on a daily basis, that it's devastating what addiction to drugs can lead to and how it can destroy families on both sides of this case, the victim's family and the defendant's family. Aside from that, Your Honor, I am standing before the court asking for you to consider 3 enhancing factors that the state has filed. The first of which is that the defendant has a previous history of criminal convictions and criminal behavior. It is undisputed that Mr. Day, the defendant, is a range 1 offender. So we're asking the court to consider the sentencing alternatives within his designated class as a range 1 offender. Second factor is that the defendant was a leader in the commission of an offense involving 2 or more criminal actors. The defendant, in his statement to Ms. James, acknowledges that at one point, Amanda Gober was living with him. And Your Honor heard the testimony of Amanda Gober at trial. Her testimony, and I'm paraphrasing, was essentially that she was the intermediary, use a different word, conducted the transactions on behalf of Mr. Day. She lived with him. Essentially, she was addicted to drugs as well. She did things for him that she didn't like to do, sexual things, was her testimony, in order to get drugs from the defendant. And this included going out from his trailer and delivering drugs to the customers of Mr. Day. She and he made up a team of players that were actively involved in the sale and distribution of methamphetamine and fentanyl. And the final factor I would ask the court to consider is that the defendant had no hesitation about committing a crime when the risk to human life was high. This case is a perfect example of that, Your Honor. Mr. Jordan Knight succumbed to his use of drugs and the sale from the defendant on October the 3rd, 2020. These 4 transactions after that you've heard testimony about all range from October and November of 2022. So the defendant was aware of Mr. Knight's death and yet continued to participate in this type of activity, which is a very high risk to human life. You heard Ms. Gober's testimony at trial that the defendant had been engaged in that type of activity leading up to October the 3rd, when Mr. Jordan Knight was sold this combination of meth and fentanyl. This activity, the sale of a Schedule II drug, is one of the highest risk behaviors to human life that there can possibly be, because the dealer and the victim have no idea what exactly is in that combination of drugs that they're selling. There can't, to me, other than just facing the barrel of a gun, this is one of the most risky behaviors to human life possible. And we're asking the court to assign great weight to that factor. Thank you.
Mr. Atchison?
Your Honor, we stand here today in a case that involves a terrible loss, a young life that was cut short, and no sentence imposed in this courtroom will ever erase that tragedy or heal that pain felt by either one of the parties' families. I'd like to begin by acknowledging that loss and say that nothing that I say here today or anybody else is meant to minimize the harm or the hurt that has resulted from this particular act. But Judge, sentencing also requires the court to look at the whole person standing before you, not only the offense, but also the circumstances, the history, and the future potential of the defendant. The law in Tennessee directs you to fashion a sentence that is just, that protects the community, but that is also no greater than necessary. General Crouch has already acknowledged that Mr. Day is a range 1 offender. This particular offense carries a significant penalty. For range 1, it's 15 to 25 years within Mr. Day's range. We're asking this court to impose the minimum sentence available, 15 years, because the mitigating factors that I have filed, I would submit, strongly outweigh the aggravating ones. Judge, the first one being that Mr. Day has a limited criminal history. Aside from the federal case that has already been adjudicated, he's not a career offender. He's not a person that, by any testimony or evidence that's been presented, has spent his whole life trafficking drugs for profit. Second, Judge, this offense arose out of tragic and unusual circumstances. General Crouch himself just stated that there's no way for Mr. Knight or Mr. Day to have known what was in that illegal drug that he voluntarily purchased and used. I don't know how we would assess that in any setting. But just like Mr. Knight, Mr. Day sits here today, like so many others in our community, he struggles with addiction. Drugs were shared or provided in that context. There was never anything on record or through testimony to prove he intended to harm Mr. Knight. It wasn't with malice, and certainly not with the knowledge that this young person would lose their life. That doesn't excuse what happened, but it helps us explain it. PSR report, Judge, also indicates a history of mental health issues that Mr. Day struggles with. Even still today, incarcerated, he's on certain prescriptions for mental health and depression. Of course, that could easily be in connection with where he's at and the situation. And last, Judge, as it relates to the catch-all factors, the circumstances of this case, including his history, would support the inference that the defendant's underlying issues with substance abuse and his own personal dependency should be considered in mitigation. Along the same lines with the PSR report, Judge, while incarcerated, Mr. Day has shown that he has the initiative to do better, to change. He's received certificates in HVAC, plumbing, and electrical trades. He's making use of his time to better himself and in hopes of being a productive member of society once released. It shows that he has the desire and aptitude to reform. And Judge, Mr. Day is more than his worst mistake. He's a father, a son, a nephew, someone whose life has value, and whose future does not have to be defined by this crime. Heard testimony from his uncle. Both his aunt and his uncle have been supportive. They've been to every one of these hearings. He testified today, Judge. And again, I don't want to take away from the grief that was expressed through Ms. Williamson's victim impact statement. And I, for one, am not asking this court to overlook their pain. We are, however, asking the court to recognize that a 15-year sentence still provides real punishment, still provides deterrence, it still protects the public, but it also leaves that room for redemption. So, Your Honor, we would respectfully request that you impose a sentence of 15 years, the minimum within the statutory range. The sentence is sufficient, but not greater than necessary to achieve justice under the law.
Mr. Crouch, anything further? Let me start by acknowledging one thing. Mr. Atchison has been appointed by this court to represent Mr. Day due to, I think, a conflict in the public defender's office. And I will compliment Mr. Atchison on the very credible and fine job he's done in representing Mr. Day and as competently as we could have hoped to have someone represent him. And I certainly understand and appreciate his position, having been there many times myself. And speak up if you want me to hear it. Oh, well, I'm sorry. I thought you had concluded your proof. Then let's let him come up and we'll have that statement before we move forward. So he needs to come to the stand. Let's come to the witness stand, if you will. I'm going to take back what I said about how good a job you did if you're going to let me slide by that. Mr. Day, you are making an allocation, if I understand, allocution rather, so I'm not having you placed under oath, but I'll allow you to have your statement.
Your Honor, and to the family of Jordan Knight, I want to begin by saying how deeply sorry I am. I know that nothing I say today can bring Jordan back or ease the pain you have suffered. I take all responsibility for my part in what happened. I will live with that for the rest of my life. I never intended for anyone to be hurt, but I know my choices and had tragic consequences. I understand that. Since my arrest, I've tried to face what I've done and work on myself. I've been working on bettering myself by completing courses in HVAC, plumbing, and electrical trades so that I can hopefully be a productive member of society after I'm released and putting my addiction and substance abuse behind me. I am committed to changing my life so that like nothing this ever happens again. I know that I cannot undo my past, but I hope one day I can do something positive with my life that in some way portrays a better version of me. I'm truly sorry for your loss, and I thank the court for allowing me to speak.
Thank you. You may step down. Mr. Atchison, is there anything else of any source that you wish to have me consider? Now, I'll give you one last chance, General Crouch. Anything else you want to say? Sentencing in these types of cases is never easy. There basically is a tragedy that affects both sides of the equation in this situation. Drugs and drug overdose deaths and the continuing problem that we have with the drug issue in this county and Cheatham County and 23rd Judicial District, the state of Tennessee and the United States presents one of the most difficult things to deal with because people desire to use these drugs without consideration. I agree with Mr. Crouch in that it is a highly, highly dangerous activity to engage in when people put into their bodies something that they have no idea of what it contains. And they are simply rolling the dice, or it's almost like Russian roulette to use drugs when you don't know what it is, and especially with the fentanyl that has come about. So it's a continuing problem. It affects families across generational lines, across socioeconomic lines, families throughout the area. Even my own extended family has been affected by these kinds of things. So I certainly understand the problem and how things can escalate sometimes for a person. So I understand both Mr. Day's situation as well as Jordan Knight's situation. I am required to impose a sentence based upon the findings of our jury in Cheatham County that found Mr. Day guilty of the second-degree murder. Second-degree murder, as we've had explained, for a range 1 offender, and it is established that he is a range 1 offender, carries a sentence of 15 to 25 years. In order to determine the type of sentence, he is not eligible for probation, so that is not an option that would even be considered by the court if it were available, but it is not available as an option. As a result, then the court has to consider the sentencing considerations that are set forth in our Tennessee Code. I cannot just set the sentence that I think is appropriate no matter what the range. I must follow the sentencing guidelines that our state legislature has imposed, or has implemented rather. And under Tennessee Code annotated 4035-103, the sentencing considerations include the following. Sentences involving confinement should be based on the following consideration. A, confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. B, confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrence to those likely to commit a similar offense. Or measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. Sentence imposed should be no greater than that deserved for the offense committed. Inequalities in sentences that are unrelated to the purposes of this chapter should be avoided. Sentence imposed should be the least severe measure necessary to achieve the purpose for which the sentence is imposed. The potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining the sentence alternative. I don't believe an alternative sentence is available or appropriate in this case. So considering those sentence considerations, mostly those that deal with whether or not a person should be incarcerated or not. In this particular case, because incarceration is mandated by the length of the sentence, that a minimum sentence, have to determine what the overall sentence should be. That will be determined by looking at both the mitigating factors and the enhancement factors. I'll start, since the state goes first, with the enhancement factors. The state has raised as the enhancement factors, number one, these are set forth under 4035-114 of the Tennessee Code. Subsection 1 of that is the defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the appropriate range. This is a little bit tricky because the convictions that he has are post-dated or occurred after the conviction that he has, or after the offense date of this. In other words, the offense date in this particular case is from October the 3rd, 2020. That is the crime for which he is being convicted and which I am sentencing. The crimes that the state has introduced and the pre-sentence report has picked up are offenses which occurred in 2022, which obviously occurred after the date of this. And as a result of that, there's some question in my mind as whether those constitute a previous conviction or a previous history of criminal convictions. In other words, they certainly are predating the sentencing hearing today, but whether those convictions will predate, constitute a previous history, it concerns me that would be an applicable provision. The second factor that the state has cited is that the defendant was a leader in the commission of an offense involving 2 or more criminal actors. I certainly find that to be the case. As the testimony has established and as General Crouch pointed out, this woman that was involved in this case, her name was Amanda Dover, if I recall correctly, was used as a go-between to insulate Mr. Day from direct contact with the people who were buying the drugs. He would sell the drugs to her supposedly, and then she would deliver the drugs. She indicated she got the drugs from Mr. Dover, from Mr. Day, and that she then delivered them to Mr. Knight, and that's how the jury found that he was responsible legally for the death of Mr. Knight. So I find that to be a factor that is applicable. The third factor that the state, and I agree that the state, that none of the other enhancement factors would have seemed to apply except for number 10. The defendant has no hesitation about committing a crime when the risk to human life is high. As I stated at the outset, and as the state has made a point, and even as Mr. Atchison on behalf of the defendant has pointed out, the risk to human life in selling drugs such as this is extremely high, and the defendant engaged in the sale of drugs. I am considering the evidence of the convictions that he has in federal court of selling drugs that occurred, I think it was 4 different convictions for the sale of drugs that occurred, as I've stated, after this, because those represent the fact that Mr. Day, even despite the fact that Mr. Knight passed away as a result of the drug use that Mr. Day was involved in, continued to engage in an activity that created an extremely high risk for the lives of other people. And I think that factor is applicable because I think those subsequent convictions reflect that the fact that at the time of the sale to Mr. Knight, or to Ms. Dover to Mr. Knight, that he clearly had no hesitation about committing these crimes, selling these drugs. It's one thing to use drugs yourself, and unfortunately Mr. Knight had a need or a problem with the use of drugs. It is quite another, to be a dealer who distributes drugs into the community, and those drugs then cause suffering among the general population, as well as the death of Mr. Knight and others, potential victims. So I find that that is a factor. So I'm ascribing, or I'm assigning great weight to the second factor, that he was a leader in the commission of the offense, and to number 10, that he had no hesitation about it. I am not assigning great weight to the first because of the fact that I still have questions as to whether those convictions that occurred subsequent to the date of this offense could be considered as a factor. In looking then at the mitigating factors that the state, that the defense has provided, there is a minor role, the first that they cite is a minor role in the offense or lack of direct involvement. And it states that the instant conviction involves a sale or distribution of narcotics that resulted in death. The defendant's involvement was indirect or peripheral as it relates to the distributor. That's taken from Mr. Day's own statement to the probation officer, Ms. James, who took the statement from him, in which he says, I don't know if they were the drugs I sold or not. I didn't have any direct contact. I didn't sell them to him, which obviously reflected a lack of remorse and a lack of acceptance of responsibility. Obviously, that has changed since he gave her that statement, because his testimony or his statement today is he accepts responsibility. So I do not find that to be a factor. I don't find him to be a minor role in the offense. I find him to be mainly responsible for it. He was the dealer who sold the drugs. Number 2, reduced culpability due to substance abuse and mental health disorder. I also do not find that having a long history of substance abuse, should be considered by this court in reducing his culpability for causing the death of another individual. If anything, his own substance abuse ought to ward him away from trying to sell drugs to other people. Unusual circumstances and lack of sustained intent to violate the law. Says the allegation is the defendant did not commit a typical act of violence, rather a homicide conviction stems from an accidental drug overdose. You can make that argument, but the state legislature of the state of Tennessee has rendered a statute that he was convicted under that simply says it is second-degree murder to sell a drug that causes the death of another individual. Period, exclamation point. So I don't find that to be a factor that's applicable. The defendant's conduct was substantially influenced by his dependency on narcotics. This is under the catch-all provision. The circumstances, clearly there might be some factor there that would have some influence, but I mean, I'm sure that his own dependency, as his uncle testified to, contributed to the fact that he was, trying to make money because he probably couldn't make it any other way. Since he had a drug addiction. Number 5, the defendant's rehabilitation, potential, employment history, education. I don't really find that to be much of a factor because the sentence length, the minimum sentence length here is quite lengthy, 15 years, and therefore I don't find that the rehabilitation aspect is really appropriate. There is no sentence that I can impose in this case that's going to heal the suffering that Jordan Knight's family has had, or ease the pain that is felt by Mr. Day's own family, extended family. That the sentence that I have to impose has to reflect the reality of the fact that we have a drug problem in this country and in this state and in this district, where people are dying as a result of this drugs being sold. And as was stated at the outset, one of the considerations I have to follow is the fact that the sentence imposed should send a message to those individuals who might be otherwise engaged in or contemplating engaging in the sale of drugs. For that reason, I find that the sentence imposed on Mr. Day that he should be sentenced to, and I hereby sentence him to 22 years in the Tennessee Department of Corrections. That sentence is less than the maximum, but more than the minimum, and it recognizes the issues and those factors that I have set forth and gives weight to both the enhancement factors as well as the mitigating factors that were cited in this case. I'm truly sorry for the loss that the Jordan Knight's family has suffered, and for the pain that Mr. Day's own family is going to suffer as a result of his incarceration. perhaps this sentence will dissuade others who might be inclined to engage in such activity from doing so. That is the judgment of the court in this case.
There is a metric ton we can unpack on this one. So I suggested that we make it our sidebar on Tuesday. Ashley says, yep, we can go for it. If the rest of you agree, I think that's where we go. This is complicated. You have, you got a guy who's addicted to drugs. He's then selling drugs, as I think Ashley pointed out in the chat. But the guy who's taking the drugs is also kind of making his choice. It's messy. This is a messy thing to talk about. And that's murder too that he was convicted of, not just like manslaughter. So, but with the drug problem now, especially with fentanyl lacing everything, which it looked like from what I read was the situation here, it was like heroin laced with fentanyl, and there's the problem. Lindsay, you put in the chat that you found an article on this. I don't know if it's one I found or not, but if you wouldn't mind throwing a link to that in the private chat so we could have that material, that would be super helpful. Please and thank you. All right, let's there's not a lot going on out in court at the moment, but let's go to Colorado, Adams County, where they're doing the zebra bond court. Let's spend a few minutes there.
Para la instrucción de cargos o presentación de cargos.
Thank you. Good luck.
Gracias. Buena suerte.
Judge, just for my purposes, I don't need the interpreter on this. What are the case numbers again?
Yeah, you bet. The felony matter is 25 CR 2729, and the misto matter is 25 M 5240.
Thank you.
You bet.
And Your Honor, this is the interpreter. Will you be needing my further assistance?
No, I do not believe so. I think that is all. Thank you so much. We appreciate you as always.
My pleasure, Your Honor. Thank you.
All right, Ms. Stoll, I can go in any order you like.
Sure. Is Spiceman still there?
She said that she didn't have anybody else.
Okay, well, then we can just go through with mine. I spoke with a couple
There she is.
I spoke with, we can do Mr. Lovett.
Okay, Mr. Lovett, come on up. Good morning, sir. This is 25 M 5241 and 25 M 5241. Can I have appearances?
Max Roth on behalf of the people.
Danny Stoll on behalf of Mr. Lovett, who does appear.
Mr. Lovett, I'm going to begin by issuing a protection order in your matter due to the nature of the allegations. In this case, I am required to, this is not a domestic violence case, therefore not governed by Brady. As such, I will activate provisions 1, 2, 3, and 7. Alleged victim is Rochelle Sowers. Her date of birth is 2/17 of 77. Sir, as it relates to Ms. Sowers, you shall not harass, molest, intimidate, or retaliate against her. You shall stay away from her home and any location where she may be found. You may not contact her directly or indirectly. You may not possess or consume any alcoholic beverages or controlled substances without a valid prescription. And those conditions of the protection order will be conditions of the bond I'm about to set for you. So if you violate any of those conditions, you could be subject to additional criminal or contempt sanctions, and you will need to sign a copy of this as soon as we're finished speaking. All right, Ms. Stoll, regarding bonds.
And Your Honor, I'm going to respectfully interrupt, probably for a good reason. I'm going to stipulate to a PR bond.
Okay. That's been what I would have been inclined to do, but wanted to hear everybody out. Ms. Stoll, did you have any further record?
Not at this time, Judge. I would just note that he's 74 years old and this is his first time being in custody. So I was going to be asking for a PR bond, and I'd also like to note that he is a veteran as well.
Okay. All right, Mr. Lovett, due to the stipulation of the lawyers, I'm going to approve a personal recognizance bond for you this morning. That's going to be in the amount of $1,000, meaning that you don't have to post any money to get out of jail today. So as long as you show up for your next court date and get this done, you're going to be okay. All right. Next court date, sir, is going to be on October 1st at 1:30 p.m. Division R for an arraignment. All right, good luck.
All right, thank you.
You're welcome.
I can then call Mr. Talley.
All right, Mr. Talley, come on up.
Good morning.
Morning, sir. This is 25 CR 2732. Again, 25 CR 2732. Can I have appearances?
Max Roth on behalf of the people.
Danny Stoll on behalf of Mr. Talley.
All right, Ms. Stoll, regarding bond.
Thank you, Judge. 1 second. So in this case, Judge, I am asking for a significant reduction in bond, if not a PR bond here in this case. I would note that I do have some competency concerns in this case. I do think some more conversation would be beneficial there.
You have some what? I'm sorry, what kind of concerns? I missed it.
Competency.
Okay, thank you. Sorry to interrupt.
I would note that he did mostly grow up in Colorado. He's going through quite a bit right now. It sounds like him and his wife are going through a separation. It's been going on for a couple of years, and that does correlate with the uptick in cases that I do see. I would note that he also hasn't worked in those last 3 years. He was a truck driver, but voluntarily walked away because he did feel like he was putting himself and his company in danger due to some of his addiction in this case. He has been living off of the money from when they sold their house during the separation and was staying in Parker. He does believe he can go back to the house he was staying in Parker. I would note, just again, my competency concerns. I do think that that is something that we can work through a couple of meetings here. But mostly, Judge, I do think that now that he knows his court date, and I have advised him on the probation in Jefferson County, I do think he will get back in compliance and write down these court dates and take advantage of the situation. I also note if competency does get raised, he is likely to get a Bridges liaison who can help him with transportation and communication with the court. He does plan to apply to the public defender here in Adams County.
All right, thank you, Mr. Roth.
Let's have one moment, please.
Yep. I'm looking at the Jefferson County case that was mentioned, 24 CR 404. I do note a number of failures to appear in that case.
Yeah, Your Honor, this is admittedly a close call, I think, for the court, but my basis for objecting to a PR bond is really the history of FTAs noted on the CPAT. I admit I don't see any assaultive history in the CPAT, but given really the number of FOJs in the CPAT, the people are objecting to a PR bond.
If I may say something for myself.
No, sir, no, I don't want you to make any statements, okay? You have a very competent lawyer. You have a very competent lawyer speaking for you, and I'm not trying to silence you. It's just that anything you say could be used against you, and I'm just trying to protect your rights, okay?
Okay.
Yeah, this is a close one. Give me just a second. This would have been a PR bond for me had it not been for the significant number of failures to appear in the other recent Jefferson County case where the allegations were robbery and violations of protection orders. So what I'm going to do here, I'm going to do the next best thing that I can do for you, sir. I'm going to give you a bond alternative. It's either going to be $2,000 cash surety, or I'm going to give you a $200 cash only option. That is a significant reduction from the suggested amount of $5,000. All right, next court date's going to be September 30th at 1:30 p.m. Division R2 for return filing of charges. Either is going to be with the supervised release program and monitored sobriety. All right, good luck, sir.
So I do have I'm sorry.
Hey, just make sure you're paying attention and then write it down with a piece of paper right here.
Yes.
Ask,
Yes.
your question.
Sorry.
That's okay.
So I can't bail myself out. I've got.
You can, you can bail it. Yeah, so it's a $200 cash only option. If you don't want to go through a surety, it's $200. So I gave you an alternative.
So I can bail out today for $200.
Yeah.
Thank you, sir. Thank you. Thank you.
Just come to your court dates and get this case done, sir, okay?
I've come with the sir.
All right, let's talk to Armando Valles Pizana. Morning, sir. This is 25M5243 and 25M5243. Can I have appearances?
Max Roth on behalf of the people.
I'm sorry, Judge, did you give 2 case numbers?
I just read it twice. I said 5243 and then I said 5243.
Okay.
I find if I word it that way, sometimes people hear things different ways better. So sorry about that.
So what's the case number? Sorry, I got thrown off.
25M5243.
Thank you.
Yeah, you bet. All right, can I have appearances?
Max Roth on behalf of the people.
Danny Stoll on behalf of Mr. Valles, who does appear.
All right, Stoll, regarding bonds.
Thank you, Judge. I'm asking the court for a personal or cognizance bond in this case. I would note that he's already talked to a bonds person and they won't assist him without a co-signer. And he doesn't have anybody that'll be able to do that here in this case other than what would be the alleged victim. I would note that he has lived his entire life in Colorado. He does work with installation and demolition. He's done that at the same company for 2 years. It is full-time. And he also does tree work on the weekends. He's helped raise his stepkids. They're 10, 13, and 17. He does have a phone. He would Uber, catch a ride, or get public transportation. He will be applying to the public defender's office. It looks like this is his first actual arrest. And he would get a hotel or stay with his family, and he will need a civil assist.
Yes, he was just before the court 3 days ago on 25M5152.
Yeah.
The allegations in that matter occurred on or about 9/23. The allegations in this matter were 9/24, the day after the protection order went into place in that one. And he's on a $2,500 cash surety bond in that matter. Sorry, I was just kind of talking through this for my benefit. Mr. Roth.
The court identified what I wanted it to consider. I don't think a PR bond is appropriate. The defendant has pretty quickly demonstrated that he either can't or won't comply with the court's orders by contacting the protected party a day after he was arrested for the initial third-degree assault. So the people are objecting to a PR bond.
Yeah. Mr. Valles Pizana, I can't give you a PR bond in this case. It's troublesome to me that the protection order was entered and less than 24 hours later, you were already violating, or the allegation is that you were already violating the protection order. So that doesn't bode well here. I'm going to set bond at $1,000 cash or surety. Next court date in this new misdemeanor matter will be on October 7th at 1:30 p.m. Division FAC for an arraignment. I'm not going to make a finding of domestic violence in the new case, nor will I issue a second protection order. All right, good luck. All right, and that leaves us with Mr. Wachel. Or is it Wachel?
Watchell, sir.
Watchell. I just wanted to make sure I got that right for you, sir. Good morning.
Good morning.
This is 25M5244. Can I have appearances?
Max Roth on behalf of the people.
Danny Stoll on behalf of Mr. Watchell, who does appear.
All right, sir, due to the domestic violence allegations in your matter, I am going to be entering a protection order this morning that is governed by the Brady Handgun Violence Prevention Act. The alleged victim here is named Diana Gleason. Her date of birth is 11/17 of 62. I'll be activating provisions 1 through 7. Ms. Stoll, will he need a civil assist?
Let me check. I don't believe so, Judge.
Yeah, I didn't think so either, but I just wanted to double check. All right, sir, as it relates to Ms. Gleason, you shall not harass, molest, or intimidate her. You shall stay away from her home and any location where she may be found. You may not contact her directly or indirectly. You shall not possess, purchase, or control firearms, other weapons, or ammunition, and you shall relinquish any such objects within 24 hours of your release. You shall also complete an affidavit and file it with proof of relinquishment with the court within 7 business days. You shall not possess or consume any alcoholic beverages or controlled substances without a valid prescription. And Mr. Watchell, the conditions of the protection order I just told you about will be conditions of the bond I'm about to set for you. So if you violate any of these conditions, you could be subject to additional criminal or contempt sanctions, and you'll need to sign a copy of this as soon as we're finished speaking.
Yes,
All right,
sir.
Ms. Stoll, regarding bonds.
Thank you, Judge. I am asking for a personal recognizance bond here in this case. There's a lot of reasons why. I would note that he does have a PR bond in Jefferson County. He does have a place to stay without the alleged victim. He has been primarily living at the homeless shelter on the 48th Street area. He's lived in Colorado for the last 3 years. He was in Texas before that and did move out here for work. He is doing contracting work for commercial refrigeration, which is the field he's worked in for the last 35 years. He has a subcontract job right now and is currently going on, and he is supposed to be there. He will lose the bed at the shelter and the job if he doesn't get out, which will prevent him from moving towards getting his own place and moving towards taking care of these cases a little bit here. He does have some children. They are grown up and live in Texas. I would note that the issue here that I see is that they are seeking, obviously, to modify the protection order for a couple of reasons. Mostly the alleged victim is dependent on him for disability purposes. For instance, she has trouble walking around, going shopping, going to doctor's appointments, and he has been responsible for that. And so that's what's been going on here. He does have a public defender already in Jefferson County, so he does qualify for the public defender's office. He does have transportation to court. And I would note that the failures to comply, the FJs here, are self-revocations where he wanted to serve his sentences through jail rather than probation. So he did already take care of those.
All right, thank you. Mr. Roth.
May I have one moment, please?
Yeah, you bet.
And shocker, I need to ask for the case number.
For what?
I need to ask for the case number.
Okay. 25M5244.
Thank you.
Yeah, no worries. And I am looking at this, Jeff, while Mr. Roth is checking his notes. I'm looking at this other case, Jeff Code 24M6609. It is the same alleged victim, Ms. Gleason. It is a domestic violence factual basis. The allegation is a violation of protection order in that matter as well. And just trying to.
And I apologize for the delay. I'm trying to be considerate here.
No, you're fine. This is our last matter, so we're good to go. I'm just looking at both this case as well as the Jefferson County case. It looks It looks to me like a lot of this, even though there are violations of protection order, a lot of this contact is mutual.
Yes.
That's my understanding too.
I'm not going to object to a PR bond, but I would ask that a condition of bond be compliance with probation. I believe Mr. Watchell is on probation in at least one case here in Adams.
No, sir.
I do not show that.
No, sir. I completed all of that, Your Honor.
I could be mistaken. Just one moment, please.
No, that's fine. I'm looking here. I do not see that he. Well, in any case, I agree, sir. I'm concerned about what's going on between you and Ms. Gleason, so it's important that you abide by the active protection order so that you don't keep drawing these cases, okay? Because this is just going to continue to snowball, and you got to get these cases put behind you and completed, okay?
Yes, sir.
So I'm going to give you a PR bond in this matter today. That's going to be in the amount of $2,500, meaning you don't have to post any money to get out of jail in this case. So as long as you show up for your next court dates, you're going to be okay. That is going to be with the condition of the supervised release program and monitored sobriety unless we can come up with probationary supervision in Adams, but I'm not seeing that.
I was incorrect.
Okay. All right. Then it's going to be with SRPMS in our Adams County case, Mr. Watchell. Your next court date here is going to be on October 1st at 1:30 p.m. Division R for an arraignment. So it's imperative that you make that court date. If you don't, I'll issue a bench warrant for your arrest and you'll end up right back there and you're likely not going to get the PR bond again. Okay.
Yes, sir.
All right. Good luck.
Thank you, guys.
To our bailiff, I have one more CPAT. We're not sure.
All right, looks like they're finishing up there. Let's go back to Judge Stevens. He has one more, I think.
Yes, is that what it is? Something. Hold on, let's get to the file. We're calling 24CO101, the state of Texas versus LaDonna Renee Lewis, which is you, ma'am. And you were here with your attorney, Mr. Nayland, and the state's attorney. I'm looking at this first letter of support from a Doriel Dorsey. Who is that?
She was a coworker.
It was a very nice letter. I mean, truly, it's this person writes very well and got the point across and thinks very highly of you. And then here's another one from, it looks like, is it Teresia Robinson? I think the T is marked out. And that's a very nice letter as well, written on your behalf. How do you know this person?
She's my current supervisor.
Your current supervisor. My current supervisor would write me a nice letter. My wife. Once. Why she thinks I'm doing well. She said, needs work. Yeah. Needs work, but yeah, I'm doing well. This her. I'm getting better, she said. Oh. Okay, earlier here, the defendant pleaded, well, it's not showing, entered, has she already entered a plea?
Yes. Yes.
Okay, this is not showing on the file, entered a plea guilty to misapplication of third-degree felony of fiduciary or financial property. And the agreement is that the defendant would be placed on probation of a type and length at the court's discretion and restitution in the amount of $8,966.09 would be part of the order of probation.
Yes, she paid back a big chunk. That's just what's left over.
Is that right?
Yes.
What is the balance? Do
Yeah,
we know?
that's about 8,000 the balance. She paid off about 24,000. It was 37,000 total.
Oh, okay.
That's the balance of it right now.
So the balance is still $8,966.
Correct. Yes, we were trying to get that done before we finished the case.
Okay. How do you have a plan? What is your plan on getting that paid back? Because that's what's in, the quicker you pay it back, the quicker you get rewarded.
Yeah, right. Yeah, back as I can.
How is that going to be done in your plan, though? Do you have like a monthly plan
Yes, sir.
about how much?
At least 300 a month.
Can you do that?
Yes, sir.
Because I'm going to order at least 300. All right. All right, have the parties had an opportunity to review the report. Are there any corrections or changes to it or comments? First of all, defense.
No, Your Honor.
Okay, state.
Judge, there is a memo that was added on from the complaining, one of the officers of the association, huh? Yeah, just got it. So it should be, I don't know if it's in there or not.
It's not. And Judge, I wouldn't object to that letter being part of the PSI. I think we were going to address that, but since I brought it up, Huseby State says that a layperson shouldn't be giving, shouldn't give testimony on the position for punishment. Also, he was a member of the same association she was. I think I'm sure he's mad, but it actually doesn't really matter on our plea bargaining anyways. But I'm just making that objection to the record that it's an improper part of the PSI.
What's the state say on it?
Judge, this was an interested party, one of the people that belonged to the association that she stole from. So it'd be like a complaining witness that is voicing their opinion about the plea bargain agreement and as well as the way it affected the members of the organization that she took from and the trust that they placed in her before she took this money.
What's the organization here? The sheriff's?
The sheriff's, yes, sir.
So a non-governmental entity made up with governmental entities.
Jefferson County Sheriff's Association.
Yes, sir.
It says right, Huseby State, 787 Southwest 2nd, 193.
Once again, has everybody read this pre-sentence report and
Yes, sir.
no other changes?
That'd be the only objection, Judge.
Okay.
Everything else is correct.
I have no objection, Judge.
sure you're reading this in the report, Judge. This is it's not like stealing cash directly from. It was mostly using the credit card for unauthorized purchases that were personal, not for business purpose.
Okay, so the point you're making.
I just want to make sure that you knew was that like just like robbing the safe in the middle of the night, or just make sure that you knew where that was, how the money came. We figured out what the restitution was. We had to look for non-association versus association. That's where there was a difference in the restitution versus what was initially alleged as well.
So, no, you're trailing off. Go ahead.
It's as long I'm just making sure that you saw that what that was in there is that it was the use of the credit card, not just going in like pulling cash out of the safe or something.
How does that?
It doesn't mean anything.
That's apples and oranges.
Yeah.
They're both fruit.
Yeah, they're supposed to. It's like she's wearing like a burglar suit, go in the middle of the night and break into the safe. That's all I'm getting at. But there's no excuse in the context, as you see, she's remorseful.
I understand, but once again, she was put in a position of trust and misused that.
Yes, Judge.
To the detriment of the organization and sometimes this happens here, and there's a big difference between people who are funneling out proceeds and then they're buying food.
Well, this was for a lot of this was for personal family stuff. There's
Cruise payments, cheerleading fees.
Cheerleading, that's children.
Come on.
But
Anything else? I mean, that stings. You know it.
It does, and
I mean, we're not talking about this is having a good time.
Right. She's also lost her reputation, her career.
Well,
else, and is paid.
What else could be expected
Nothing.
in this?
Nothing.
She betrayed a position of trust, and when you're given a position of trust, you have a lot of flexibility and freedom, and numerous people rely on the integrity and the honesty of it. And here we're still out. I mean, that was a significant amount. Good thing you paid as much back as you can, because a lot of times folks don't. But here it's still thousands of dollars are still missing, and we're talking about losses since August of 21. This is over 4 years later, and the loss of value of it, is still, that adds up.
Yes, Judge. And we've been doing it for some time too. I think she paid this back before she was charged.
Did she pay back with interest though? No.
No.
I know that doesn't happen, but we all agree it ought to be.
I understand.
It's just not the way it is. Right. But nonetheless, even when they get back the last dime of the actual money lost, they've lost the value over 4 years of it, so they're out.
It's not, and I'm not discounting anything.
I know. Let me see this case you're talking about.
The difference that we're talking about is whether it's a deferred probation, whether it's conviction or not. And you can also make a finding that it is not in the interest of justice to ever steal this. And I'd be perfectly happy with that. I just don't want her. I want her to just pay for what she did, but not be forever.
Yes, sir. I understand.
For it. And that was the kind of the
you're
issue.
Being a good lawyer. That's you representing your client vigorously. Good. You many times folks don't hear, and that it's always a good thing, because that's important.
And I didn't highlight the part of that, Judge, but it's pretty much just the last point of error. Just says that lay witnesses should not give an opinion on proper confinement and punishment, and that's really all it is. A lot of other points of error don't matter for our case.
I'm going to highlight.
Oh yeah, absolutely. That's your copy, Judge. I just didn't want to touch your copy if I was giving it to you. I tried to be suggestive. It's just argumentative instead.
Okay. Let me see that letter.
It's right there, just.
No, here, you can have that. back. Okay. You were referring to obviously the last
Just
two of the last three sentences.
Correct, Judge. That's
Okay.
correct.
All right. And the court has, the district attorney's office has requested the court consider this. And this is referred to as a supplemental PSI report memorandum. And it's from Caleb Mitchell, who is president of the Jefferson County Sheriff's Association, I presume. And your objection is noted, and the court is not going to consider the first and second sentence of the last three sentences of that, but I am going to consider everything else.
Yes.
Because everything else does speak to the harm that occurred to the organization, which is the entity that seems, which is the actual victim in this case, the Jefferson County Sheriff's Association. So, but once again, people from time to time make comments about what the punishment should be, but only the jury and the court really has that final determination, depending upon what the defendant elects. So, anybody else want to add something here?
Nothing further, Judge.
Okay, your request on behalf of the defendant is what?
I'm requesting for a deferred adjudication, and you are very welcome to make a finding that it's not in the interest of justice to ever be eligible for non-disclosure. The statutory authority does allow you to do that. And if you do make that finding, then she can't seal this in the future. And I know that's the big issue is they don't want her to be able to hide this in the future. They wait down the road to ever, be put in that position of trust. And we have no problem with you making that finding, Judge. I think that would be highly appropriate in this case to make the Jefferson County Sheriff's Association possible in their feelings.
Anything else?
And of course, the restitution, Judge, we know she must be active. Last part.
And
Judge, because of the position she was placed in and the organization she was placed in a position of trust that allowed her to work without them looking over her shoulder because they did trust her, and then to come back and find out that she's taking money from them. It's not only hurt that, but it put a black eye on the association itself. So we're asking for a straight probation, that she have a conviction, that follow her everywhere so everybody knows, look out, because if she gets in financial trouble, this is a possibility. We want to make sure that we protect further future victims. And we also make sure that the position she's placed in know that they need to keep an extra eye on her if they do place her in a position of trust. So I think it's a fair resolution for the fact that she took it for such a long time and for the money that she took and from who she took it from.
Okay. And ma'am, is there anything that you would like to add here, Ms. Lewis, before the court makes its decision? This is your time. Your attorney has spoken for you.
I prefer she wouldn't, just always makes me
well, it's
scared.
whatever you wish. And you certainly can follow your attorney's advice. Yeah, nothing else?
Yes, sir.
Okay. You did make a statement to the pre-sentence officer, and here it's related in 2 paragraphs here on page 2. So you stand by that. Okay. Anything else?
No further, Judge.
All right. If nothing further, the court is going to find that Ms. Lewis, you have pleaded guilty in this case to misapplication of fiduciary or financial property, a 3rd-degree felony. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at your hearing to find you guilty beyond a reasonable doubt. One final thing, how much credit does she have on service? How much do you have any time serving in jail on this? You went in and bonded out, I guess. She says there's none. I trust that she would know better than anybody else.
Yeah.
One day, that was when you came in and then bonded out immediately, and they give you credit. All right, here's the court's ruling. I find you guilty beyond a reasonable doubt of this offense, and you are hereby said that's a 3rd-degree felony. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. But I am suspending that and placing you on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You had a total loss. There was a total loss here to the Sheriff's Association in the amount of $37,102.91, of which a balance toward that replacement or restitution of those funds in the amount of $8,966.09 shall be ordered to be paid as a condition of probation. And you said, I think, that you could pay as much as $300 per month.
Yes.
And that will be ordered. At least $300 per month will be ordered to be paid toward restitution. There will be terms and conditions of probation, which are normal and customary. The court would also add for the record, this particular situation and crime involved illegally taking advantage of a position of trust. You understand that. It's obvious that you have admitted in an attempt to resolve this in an appropriate way. I just wish we could have talked you into not making those choices in the first place, because these are clearly wrong. And something like this is ultimately going to collapse. Somebody's going to find out about it. There's going to be an audit. It's just waiting to fall. It's a shoe waiting to fall. And maybe that bothered you and kept you up at night. But nonetheless, you had, according to the pre-sentence report, 186 separate transactions that you illegally accessed since August of 2021. And these involved expenditures of that had absolutely nothing to do with the purpose of the money that was properly placed into the sheriff's organization, sheriff's association, that should have been used for the purposes that the sheriff's association statements in their incorporation and what that professional entity was entitled to use those for. And those are limited purposes, but it had nothing to do. It had absolutely nothing to do with what you accessed improperly and used those that $36,515.34 for, such as your daughter's cheerleading, childcare, school fees, rent, utilities, and personal subscriptions, and other personal matters, which also included airline tickets. And we can go on and on, but I think the point is made. You understand it. You have admitted responsibility and are pretty much throwing yourself onto the mercy of this court and your intent to help your kids enjoy life and provide for them and what they wanted, contradicted with the obligations that you had in your responsibilities of honest maintenance and control of the Sheriff's Association monies. And so when something happens like this, the price is serious, as it should be. I just wish I could have whispered in your ear, don't do this at the beginning. But you have accepted responsibility, and that is important. Now, these also, such a betrayal of trust also doesn't just walk out of here without the issue of I can assess up to 180 days in the county jail as a condition of your probation. What do the parties say to that?
Judge, in these kind of cases, the court has always given some that's a discretion as far as the time. I don't know, since she's paid some back, she should be given some credit for that.
I think so. Yeah.
So somewhere around 30 days, maybe up front.
Judge, now if we want her to pay restitution,
Sir?
he's got $8,000 left. Putting her in jail is going to take her. I mean, she has a job that now she's going to pick a felon. We don't want her losing her job and not being able to pay restitution back. That really kind of wasn't our agreement on our plea bargain. We talked about a term of probation is the length and the type, not the condition. I understand that,
but your argument is don't hold me hostage.
Not only hostage, Judge, I'm just.
I know you don't, but
I'm giving Mike a hard time because he asked for jail.
You're vigorously
what we agreed on. So
and
this is personally between me and him, not the court.
Or
that was not well, it wasn't part of the plea agreement.
Correct.
That's correct.
And
it wasn't.
My discretion.
I understand that.
I can do that up to 180 days, and she's going to go to jail.
Well, with
anybody in a position of trust like this, it's going to go to jail. But what I'm going to do is, what are your days of work?
Monday through Friday.
Monday through Friday. I'm going to order you to serve 30 days in the county jail on successive weekends, beginning each Friday. You must report on before 6:00 p.m. You'll be released Sunday, and that'll be for 15 weekends, successive weekends, as a condition of this probation. Do you understand? Can you work that out? When can you begin that? Today's Friday. I'm going to give you 1 week. Is that enough time? Beginning next Friday, on or before 6:00 p.m. in each successive weekend, until 30 days are served, or unless this court decides otherwise to reduce that time. Dustin, did you hear that?
Yes, Judge, I was making sure.
Okay.
That's clarified. Correct.
Okay, you just want to.
So next Friday
Has
after-
discretion, and
Actually,
we'll see how things
Talk
play
to
out.
me. Okay.
And this restitution, let me ask you this. This still is not $8,966. Is there any possible way you're able to pay that restitution earlier than over time? I don't know. I'm just asking you that. I reward people who do that, if you know what I mean.
Yes,
Towards conditions of probation. Okay,
I've talked with her about it.
all right.
She's
See what you,
figured that out.
all right. Did we cover all the bases on this? Anything else?
Okay.
If not, we are in recess on this.
Thank you.
I'll sign, yeah. Let me sign these orders and get the probation office to get copies to everybody.
Okay, friends. First, sadly, we weren't able to get to Dungeon Court this week because we got caught up in some other important hearings, I think, and things that were worth watching. So we'll try to get back there next week. For those of you who weren't here at the beginning of the show, this incredibly generous community threw down 100 gifted memberships today before the first half hour was even over. And Bailey threw in a couple of super stickers to just kind of top it off. And I wanted to let you know, those of you who donated those, we've already gotten a thank you from one of the new members. They posted it on one of the videos. So I wanted to let you know that recognition of that has started now. And I also want to let you know again, and I know I say this a lot, but I need to keep saying it. The generosity of this community, your support that you show me, the grace that you have with each other, none of this stuff ever goes unnoticed or unappreciated, and I want you to fully understand that. Again, I get myself up early every morning, and I look forward to sitting down and spending time with you guys and being able to bring these courtrooms to you and shepherd this community along as best I can. And we're not even quite a year old yet, a few days away from that. But it means the world to me, and I want to make sure that I make that clear. I'm going to do everything I can, as I have been, and I'll continue to do everything I can to be worthy of all of this, because it's not a small thing what you guys are doing for me. It's not small at all. It's huge, and I feel the need to let you know how much I appreciate it, and I promise to do the best that I can. Not always going to be perfect. I'm really good at hitting the wrong buttons, for example, but I'm going to continue to give it, as I have right from the start, everything I've got, and I want you to know that. And again, thank you so much for everything you've done for me and everything that I know you'll continue to do. And we're almost to 25,000. I think we're like 23 away or something like that. So we'll see you tomorrow night for game night, 8 p.m. Eastern, 5 p.m. Pacific. We will see you Monday morning, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. Beth and I are going to talk this weekend. I think we might expand the pre-show a little bit, but more on that to come. Please go have yourselves a good weekend. Thank you all again. I really do appreciate everybody. Take care. God bless.